Harassment and discrimination are illegal in Colorado and not tolerated in any workplace. Harassment and discrimination can inflict serious damage on an organization's productivity and morale. They cause absenteeism, employee turnover, depression, illness, embarrassment, and humiliation. And individuals named in complaints could lose their jobs, their reputations, and even their careers. Workplaces in Colorado are governed by the Colorado Anti-Discrimination Act, CADA, the Power Act, and federal law. Colorado defines harassment as unwelcome conduct that is subjectively offensive to the individual alleging harassment and is objectively offensive to a reasonable individual who is a member of the same protected class. Colorado harassment law is one of the most employee-friendly in the nation. Unlike most harassment laws, Colorado places the burden of proof on the employer. Once a complaint has been filed, employers must prove their innocence rather than employees proving their employer's guilt. Additionally, Colorado does not require the federal standard for harassment to be severe and pervasive. Colorado law looks at the totality of the circumstances in which harassment occurred. Even petty slights, minor annoyances, and poor manners may rise to the level of illegal harassment, depending on several factors: the frequency, duration, location, and nature of the conduct, whether slurs and epithets were used, whether the conduct was threatening in nature, the power differential between the parties involved in the conduct, the number of people involved in the conduct. Harassment is broken into two categories: quid pro quo and hostile environment. Under Colorado law, quid pro quo harassment must meet one of two requirements. 1. The harassment must be made explicitly or implicitly as a term of employment for that particular individual. 2. An employment decision must be made based on the conduct or communication in question. Quid pro quo harassment often occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. This includes work assignments, hiring, termination, promotions or demotions, positive or negative performance reviews, or any other job-related benefit. Managers and the organizations they work for can be held liable even if a threat was not carried out or if a threat was only implied. For instance, a manager who suddenly blocks a subordinate employee's promotion after that employee asks the manager to stop rubbing her shoulders could be guilty of quid pro quo harassment, even though there was no verbal threat of adverse employment action. Enduring harassment as a condition of employment is another form of quid pro quo harassment. For instance, it's illegal for a warehouse manager to tell his employees that they will simply have to ignore culturally offensive comments from their coworkers because they are commonplace in blue-collar jobs. And it would also be unlawful for a restaurant supervisor to tell employees to put up with racial slurs from customers because it's part of the job of being a server. Quid pro quo harassment is a serious offense. Just one instance is usually sufficient for a plaintiff to win a lawsuit. One single mistake could end a manager's career. The state of Colorado defines hostile environment harassment as conduct that interferes with an individual's performance in the workplace, therefore creating an intimidating or hostile working environment. Hostile environment harassment can occur between employees of the same gender identity, between employees of different gender identities, and between employees of any rank or position in an organization. Inappropriate conduct can create a hostile work environment even if it's not directly targeted at the person making the harassment complaint. Harassment doesn't just happen between coworkers. The law covers harassment between employees and non-employees who work in the workplace. Non-employees include unpaid interns, independent contractors, and employees who are contracted from third-party companies to provide services in the workplace. Additionally, harassment can be perpetrated by third-party workers, like vendors, facility security workers, visitors, and even customers. Harassment can occur anywhere that employees represent their organizations. This includes work parties, dinner with clients, conferences, trade shows, sales calls, and charity events. Harassment can occur during virtual meetings, telephone calls, email, text, instant messaging, or any other communication, even if the harasser, victim, or both parties are working from home. Under Colorado law, it is a discriminatory or unfair employment practice for an employer to discriminate in employment decisions based on or because of a person's protected class. These employment practices include refusal to hire, termination, refusal to promote, demotion, discrimination in matters of compensation, discrimination in the terms, conditions, or privileges of employment, retaliation for engaging in a protected activity, such as opposing termination. Illegal harassment and discrimination may occur without economic injury to or termination of the victim. Federal and Colorado court rulings have established protected groups that are afforded legal protection from workplace harassment. These groups are defined by race or color. Color refers to a person's pigmentation, complexion, or skin shade or tone. Race refers to all characteristics typically associated with race, including hair texture, hair type, or a protective hairstyle commonly or historically associated with race, such as braids, locks, twists, tight coils or curls, cornrows, bantu knots, afros, and head wraps. Ancestry or national origin. Ancestry and national origin refer to the country or place that a person was born, or from which their ancestors came. Physical, cultural, and linguistic characteristics of a particular country or region are also protected by law. Creed or religion. Creed and religion are defined as all aspects of religious beliefs, observances, or practices, as well as sincerely held moral and ethical beliefs as to what is right and wrong. A person does not have to be a member or follower of a particular organized religion, sect, or faith tradition to have a religion. Disability. Disability is defined by the ADA as a physical or mental impairment that substantially limits one or more major life activities, a history or record of such an impairment, or the perception that a person has such an impairment. To be considered a qualified individual with a disability, employees must be able to perform the essential function of their job with or without reasonable accommodation. Essential functions are the necessary duties and activities of the job. Reasonable accommodations are changes in the work environment or the way things are usually done that allow employees with a disability to perform the essential functions of their job. Employers are required to make reasonable accommodations for employees with known disabilities, unless the employer can show that accommodations would cause an undue financial burden or hardship on the operations of its business, or providing the accommodation would pose a direct threat to the health or safety of the employee or others. Marital status. Marital status refers to being married, single, or married to a member of the same sex. Being married or engaged to a coworker is also covered with several exceptions. If one of the spouses would exercise supervisory, appointment, or dismissal authority or disciplinary action over the other spouse. If one of the spouses would audit, verify, receive, or be entrusted with monies received or handled by the other spouse. If one of the spouses would have access to the employer's confidential information, including payroll and personnel records. Sex, sexual orientation, gender identity, and transgender status. Gender identity is a person's innate sense of their own gender, which may or may not correspond with the individual's sex assigned at birth. Gender expression is a person's way of reflecting and expressing their gender to the outside world through appearance, dress, and behavior. Sexual orientation means a person's identity in relation to the gender or genders to which they are sexually, romantically, or emotionally attracted. Transgender refers to persons whose gender identity differs from their sex assigned at birth. A transgender person may or may not have a gender expression that is different from the social expectations of the sex they were assigned at birth. Pregnancy. Pregnancy includes pregnancy, childbirth, or medical conditions related to pregnancy or childbirth. Employers must provide reasonable accommodations to employees with conditions related to pregnancy, childbirth, or a related condition. This includes providing a location to express milk, flexible work hours, and less physical work duties. Age. Age refers to employees over 40 years of age. Persons under 40 are not protected from age discrimination. Genetic information. Genetic information includes information about genetic tests and the genetic tests of family members. Genetic information also includes an individual's family medical history. It's also illegal to harass or discriminate against people because they are perceived to be members of a protected group, even if they aren't actually members of that group. For instance, it's illegal to harass a coworker for being Jewish, even if she isn't actually Jewish. It's even illegal to harass employees because of their association with members of a protected group. For instance, it's illegal to harass an employee because of his wife's nationality. Colorado law uses the reasonable individual standard when determining if offensive conduct is illegal. In other words, would a reasonable individual, who is a member of the same protected class as the complainant, find the behavior objectively offensive? The following conduct is unacceptable in any workplace and, when targeted toward a protected group, could lead to illegal harassment: ridicule, mockery, insults or put-downs, physical assaults or threats, intimidation, or physically blocking a person's movement or ability to work, the use of demeaning or offensive names or the use of slurs or epithets, jokes, banter, or remarks that are demeaning or degrading, gossiping or spreading rumors about coworkers, menacing looks or gestures intended to threaten, intimidate, or humiliate a coworker, texting pictures, messages, or videos that offend, demean, or harass a coworker, sending offensive or harassing emails, viewing offensive websites, and using social networking sites for harassing or offensive behavior. Some specific examples of harassment and discrimination include sexual harassment, which includes any continuous, unwanted behavior of a sexual nature, whether physical, visual, or verbal. Disparaging comments about a person's job ability, such as, "He is too old to understand technology." Making derogatory jokes or comments about a person's transgender status. Intentionally and repeatedly using the wrong name or pronouns to refer to a coworker. Inappropriate remarks or jokes about pregnancy, childbirth, or medical conditions related to pregnancy or childbirth. Offensive gender-based comments or behaviors that demean people simply because of their gender, such as, "A woman's place is in the kitchen, not the boardroom." Excluding or isolating employees from work-related activities and assignments because of a non-work-related reason, race, religion, gender, or sexual orientation. Harassing or discriminating against a coworker for wearing their hair in a head wrap. Refusing to provide reasonable accommodations that may be necessary because of an employee's or applicant's disability or pregnancy. Employees in Colorado have the option of filing a complaint with their employer, the Colorado Civil Rights Division, or the EEOC. The Civil Rights Division and the EEOC require that a complaint is filed within 300 days of the alleged incident. Although some information must be divulged in the process of investigating complaints, confidentiality is guaranteed to the greatest extent possible. Once harassment has been reported, employers are obligated to investigate it, regardless of how the complaint was submitted. It is illegal to retaliate against employees for participating in a protected activity. Protected activities include, but are not limited to, opposing harassment, making or participating in a harassment complaint, and requesting reasonable accommodation for a disability or pregnancy. This means that if a manager punishes an employee who participated in a protected activity with things like less desirable work assignments, less overtime, and poor performance reviews, they have broken the law. Likewise, non-management employees cannot bully, harass, intimidate, or threaten coworkers for participating in a harassment complaint. Even if the complaint is found to be without merit, the participants are protected if they have a good faith belief that harassment occurred. Harassment has consequences. Both harassment and retaliation can result in disciplinary actions, including written warnings, suspension, demotion, and termination. Harassment charges often affect future career advancement and may even hamper the ability to be hired by another organization. The loss of personal reputation and trust with coworkers, friends, and family can be devastating and life-altering. What can you do to prevent harassment? It's simple. Leave offensive behaviors at the door. Treat everyone with respect. Speak up when you see harassment. Every employee deserves a safe, comfortable environment at work, a workplace free of harassment and fear, and full of respect. It's up to everyone to do their part in preventing harassment.